Let's put the spotlight on another important issue that we have time and again debated and discussed, giving you examples of how this specific law is often misused and gets used simply as a tool of harassment. I am talking about the Sedition Law. 124A of the IPC, which refers to speech or action or any kind of writing which will incite hatred against the government. It deals with attempt to excite disaffection towards the government. It talks about giving imprisonment for life for major offences of sedition or seditious activities, 3 years of imprisonment for minor offences. Now, today the top court of our country was hearing a plea by a former army officer challenging the constitutional validity of the Sedition Law on the ground that it causes chilling effect on speech and is an unreasonable restriction on free expression, which is a fundamental right in our country. The Chief Justice of India made some very, very interesting observations. He said that this dispute about law is concerned. There is dispute about this law because it's a colonial law. Something that we've told you and our experts have told you repeatedly on our show. The Sedition Law as it exists in our country today was actually devised by the Britishers in a bid to suppress any kind of revolution, revolt, freedom movement. It was used by them against all our freedom revolutionaries from Mahatma Gandhi to Tilak, etc. And that's exactly what the Chief Justice of India has now quoted and cited. And gone on to then ask, is the law still necessary 75 years after independence? The government is taking out many laws. I don't know why they are not looking into this. He also then says, why is he talking about it? Because the executing agency, particularly the authorities, misuse the Sedition Law. And that the Supreme Court's concern is misuse of law and no accountability of the executive agencies. A point that we have over and over made here on the urban debate on Mirror Now. Look at the instances. As we speak, the latest one that has come in is an incident in Haryana where over 100 protesting farmers now face the sedition charge. This is after the Haryana Deputy Speaker's car was attacked on July 11th. They were protesting, this car and the entourage was driving by and the car was attacked. And now the sedition charge has been slapped here. Sedition law was in news when it was used to book a young environmentalist, Disha Ravi, in the so-called famous toolkit case. At that point also, the Supreme Court had made comments about how it should not be used in such a manner to intimidate people, to stigmatize. Sedition law has been used in FIRs against journalists repeatedly, multiple times, politicians, the most recent one being with Shashi Tharoor and journalists, where FIRs were filed in 5 different states against farmers for protesting against the laws that they feel will impact their livelihood. Sedition, in fact, was once used against a school authority for a play that was organized by little children. It's been used against activists, journalists, and it simply gives the authorities space to put people behind bars in an easier manner. Getting relief under the tough laws, whether they are UAPA or sedition, is very, very difficult. So tonight we ask this question again. Irrespective of what the Supreme Court may believe in, may do, may not do, as a country, should we still have a law like this, which was designed by the Britishers to keep a check on Indians? Does our government need that now? I say good evening to Vivek Reddy of the BJP, Kailash Vasudev, Senior Advocate with the Supreme Court, Dr. Vikram Singh, former DGP of Uttar Pradesh, Justice Gyan Sudha Misra, former judge with the Supreme Court, also joining us. Justice Misra, let me start off with you. Do you think it is time for us and for the government to do away with this law?
You see, it's heartening to note that the Supreme Court has taken note of a relook of this provision, because we are all aware of the misuse of this provision, which has, compelled us to think about it, whether we should, continue with this provision or not. To start with, I would say that, every law, whether it's a law of sedition or not every law, but most of the laws has an inherent difficulty of getting misused. So to start with, just the misuse of a law would not be a reason to do away with a particular provision. Like you might be aware, there are so many women-related laws also, like Dowry Act, then most, rampantly alleged to have been misused 498A, and domestic violence, and so many other provisions. But the question is that if there is an inherent, inherent probability or a danger of any law getting misused, should that be straight away done away with? In my experience, I have noticed right from 1950, the law of sedition, in some way, not exactly the law of sedition, but a potential danger to the law and order and the public security, a danger of getting misused. So, but none of them have been done away with. All of you, all very well informed participants are there. You must be right from 1950. Then Maintenance of Internal Security Act, which was done away with and replaced by National Security Act. Then Armed Forces, some provisions given to the army to stop, declaration of misusing a particular terror-infested area. But none of the laws have been totally done away with. So what I'm trying to put across is that this provision, it would be, misuse alone would not be a reason.
Okay.
But yes, to my mind, it definitely requires a relook, looking into the misuse of the law and bringing the people in the net. So many innocent people in the net. So, but the Supreme Court has taken notice of this provision, and I'm quite sure that there would be checks and balances. Here, if I can illustrate my point, under the National Security Act, it's a very stringent provision, like you can put the person behind the bars at least for 10, 12 days, and then the maximum period is 1 year.
1 year, yes.
And that can be, extended also. But in that, there is a check that the matter goes before the advisory board of the High Court, where there is a committee of the judges and the police and law enforcing agencies. They're all represented. So there is a check on the misuse of the law after the Maintenance of Internal Security Act created havoc.
Yes.
So we came across the National Security Act. So to my mind, it's a very happy position that the Supreme Court has taken notice of it, and all dimensions will be taken care of, where it requires checks and balance, where it requires some kind of a supervision by any authority, and all of it will come, because we cannot turn a blind eye to what is happening, under the garb of 124A.
Okay.
It's difficult to visualize to what extent can the law enforcing agency can go without even a prima facie case, which is very basic, to put someone behind the bars. And then if you say, the courts will look into it, at least I'm not a votary of that. And definitely it requires a relook, but it would be a very strong statement to make that it should be straight away done away with, with a kind of experience many a times, not always, but once in a while we do get it.
Okay, so
even if it is a scare,
yes.
Even if it is even if it is a scarecrow or rather a draconian law, we will have to think to put, we'll have to put something, put in place what are
for what is needed,
how it's being misused.
Right. Okay. So you're saying that just because it is being misused cannot be the only ground for us to do away with it completely. In fact, just to illustrate what the Chief Justice himself thinks of this, he said it's an enormous power in this section, and it can be compared to a carpenter being given a saw to make an item. But the carpenter actually uses it to cut the entire forest instead of a tree. That's the comparison that he gave, Mr. Kailash Vastev. A few weeks before this, there was another case in front of another Supreme Court bench where Justice Chandrachud had also highlighted the fact and the need perhaps to maybe redefine the sections and what, where it should apply and how it should apply. Would you then agree with Justice Misra that if not completely do away with it, we should maybe look at changing it?
Good evening. It was nice to hear Justice Misra with her clarity of mind telling us what she feels about it and taking a balanced view. On this whole issue of the sedition law, I have a bit of a different position, especially with regard to this particular act, which is said to be sedition or an act against the nation. If you analyze the Indian Penal Code and the position of this particular section is in a particular chapter dealing with conspiracies. The conspiracies go up to the extent of saying waging war against Asiatic countries. So if you look at the whole gamut of the law, it is essentially by the British for the protection of the colonies as ruled by them. In the Bal Gangadhar Tilak case, where the first of the decisions was rendered by the Bombay High Court, they approved the quashing of the proceedings against him in the division. In the 1940s, the federal court took the same view. In 1951, I'm giving you a few cases just to tell you how the courts have taken this. 1951 had the first case on sedition post-independence before the Punjab High Court, the then undivided Punjab, in Tara Singh's case. In all these cases, the courts have taken a view that making statements against the government is not sedition. We, as Justice Misra pointed out to you, we've had a whole spate of laws for the purposes of quelling or restricting fundamental rights. And now we are using sedition as a charge. See the judgment in Vinod Dua. See the judgment in Patricia McKean, the kind of observations by the court. So now, notwithstanding the judgments of the court, including the 1951 judgment of the Punjab High Court saying that this act is invalid on the constitutional scheme considering on testing on Article 19 principles, there is no need for anyone to continue with this act of sedition, because sedition today is becoming something which we are holding against everybody for the purpose of suppression of rights. If you're going to suppress rights by using a draconian law used by the colonists, I think it is a very wrong situation which we are facing in our country. We have got to get rid of this act or make it specific and more specific in its observations. Being a criminal case, it has got to be a situation where it is to be used for the purpose of which it may be enacted, something against the government. But for that, you have got a whole spate of acts which have come in post-independence. So therefore, if you can take action against the others, for the purposes, for example, under the Army Navy Acts, mutiny is an offense, mutiny is against the country. So that leads to a death sentence. In the UAPA, in the NDA Acts and so on and so forth, you have very stringent provisions for taking actions against those who act against this country. Why do you need an act or a provision in law which itself has been established by judgments of the court, both pre-independence and post-independence, to be those which infringe upon rights? A law infringing upon rights can be struck down as being arbitrary and discriminatory. The Supreme Court says an act which is a statutory provision which is either arbitrary or discriminatory can be struck down apart from the basic principles on which acts are invalidated. So therefore, it is my personal view, an act of this kind, which has been abused time and again, a provision of law which has been used for the purposes of suppression of any kind of independent thinking, should not be allowed to stay on the statute books. It has to go. If the Chief Justice says it, he has expressed his opinion, if I may say so, where governance is moving away from sanity to that, to restrict rights. It is time that we looked at all these acts and reconsidered what is necessary in the larger interest of a democratic system and a lovely country called India.
Yes, and may I just add that, it's not to say that instances of sedition law being used in a way to target people or harass people or silence the dissent or for any other reason which was not what it was meant to be, hasn't happened in the past. It's happened under, for several decades now. I think it's just that in the recent past, there have been way too many cases from various parts of the country, and I've landed up in the higher courts where the courts have given this kind of a commentary. For example, Mr. Vikram Singh, even here the Chief Justice says the powers are so vast that a police officer who wants to fix anybody for playing cards, for gambling, etc., can also invoke this section. And that is perhaps a reflection of the different kind of cases we are seeing where this law is being used and finally being struck down by the court as a charge against the accused.
Getting married outside the community is also being got into this.
Yes. Mr. Vikram Singh, I'm not too sure if he can hear us.
Tanvi, there's an audio problem. I was unlucky to miss the words of wisdom of Mr. Kailash and Justice Sudha Misra. But if you could repeat the question, I'll try very bravely to answer your queries. Please.
No, so your view, because the Chief Justice of India also says that the powers of this law are so vast that, if a police officer wants to fix somebody even for playing cards or gambling, they can do it under Section 124A.
You probably, everybody, and rightfully so, we have been portrayed as the villains of the worst order, and rightfully so. We deserve to be painted as villains of the worst order because we have earned this reputation. But I would like to say all our laws are colonial, barring a few like the Dowries Act, like the SC/ST Act, like the Makoka. But 90% of our statutes are colonial, number one. Number two, law should be contemporary and law should be people-friendly. And the misuse of law, as Justice Sudha Misra ji very eloquently elaborated, it is difficult to identify a single statute or a law which is not likely to be misused. The fault lies not with the machine gun, but with the person who is behind the machine gun and the person whose mindset and the way his mind is wired. Therefore, to follow the law, because it has been misused, it would be very unfair to the law. Indeed, you must have heard, Tanvi and the respected esteemed panelists, the Supreme Court has come down heavily on the police and MHA because they invoked the provisions of Section 66A of the IT Act, which was struck down by the Honorable Supreme Court many, many months ago. And this be the state of ignorance of law, then what can we say about other statutes and laws? Laws tend to be misused, and we have come to the days where shoddy investigation and bad prosecutions go unpunished and unnoticed, which is a very sorry state of affairs. I would much rather that any single and malicious charge sheeting, any malicious person, way a person is imprisoned and put behind bars is a cause of concern. There are no bad soldiers, there are only bad generals. I fault the police leadership totally for the fact that if there is a miscarriage of justice by way of perverse registration of a case, perverse investigation and a malicious charge sheeting of the case, it is for the police leadership to rise to the occasion and give an excellent account of themselves, rather than all police officers, starting from the rank of constable right up to retired DGs, are branded as villains of the peace. Thank you, Tanvi.
No, Dr. Singh, you're right, and I don't think, I would not brand the police as perhaps the biggest villain when it comes to this issue. More often than not, the instances that we see where sedition is used is because the powers that be in that state would want this law to be used. क्या use करके उसको जेल में डाल सकते हैं लंबे टाइम तक कि वो बाहर ना आ पाए, बोल ना पाए, अगली बार बोलने से पहले सोचे. That's the idea, and hence the sections are then put into place. So I just want to say that to you. This is not purely putting the blame on the actual investigating officer or the police department that uses this section. But the point is that court after court is now saying that you cannot use sedition law to silence the people or or quell the dissent which is there. Mr. Singh.
Tanvi, may I?
Yes.
Tanvi, of course, the Supreme Court, the honorable courts, and the respected lawyers are the guardian angels of our society and the nation. But at the same time, the police also, like the statutes, have often been put to use, disuse, misuse. But there are honorable officers. But you say that if at all somebody has to be fixed, there are standard operating procedures that have become a part of the police DNA, as they say that hangamae giriftari mein munasib chot pahuncha ke giriftar kiya gaya. And when I wish I could tell you, but I'm on the national television channel. Of course, I would not like to disclose privileged communication that I have received. But you have a very pertinent point. Once a corrupt and a police officer who has a particular mindset decides to fix a person, is free to use any number of statutes, any number of provisions to fix, and he knows that he has the backing of the powers that be, and there is no looking back. That also is a possibility, and I don't say possibility, that has happened in very many cases. But let us not live in an illusion. Waging war against the state is not political dissent. Again, we should not, in the backdrop of all the terrorist activity that we see from Kashmir to Kanyakumari, from West Bengal to Gujarat, let us not, in fact, give up our armory and our arsenal in the illusion that there will be no anti-national activity and there will be no sedition. Go to Wikipedia. You will see most of the advanced countries like USA, Australia, Canada, Singapore, Hong Kong, all countries, I'm not talking of Israel or China, all have sedition laws, anti-sedition laws, and in place. The punishment and the sentences are much, much higher than what we propose in our Indian Penal Code. Therefore, Tanvi, I would say, it needs to be looked into, it needs to be examined, perhaps also investigated by a senior officer, as in the case of Dowry Act, as also in the case of SC/ST Act and many of the statutes, that confession made before a gazetted officer or superintendent police only would be acceptable, otherwise not. We need to upgrade the investigation, and also, if at all there is a confession and other incriminating material will have to be vetted, scrutinized, and then the charge sheet would go, if it is approved, say, by the district magistrate and the Inspector General of Police.
Okay, we were just looking at some of the statistics as well. There's been a 28% increase in the number of sedition cases filed each year from 2014 to now. I think a big jump and chunk of this actually came during the anti-CA protests and people protesting in various places. Some of it was also the many accused that were booked during the Hathras case and the coverage of this case and the protests and the outrage around it as well. That actually goes on to say, also show you where and how is it being used more than just for terrorist activities or those who may actually be indulging into anti-national activities. Justice Misra, before I go across to BJP and Vivek Reddy of the BJP, since you said that your view is that maybe we need to look at fixing the issues and the loopholes which are there within the law so that it's not abused to this extent. To your mind, how would you go about it? Define it, define where it can be used a little bit more, put in some more checks and balances. How do we approach this?
See, it requires a very serious deliberation. But what comes to my mind is that maybe we can have something, parallel to what is there under the National Security Act, some kind of an advisory board where, just to give a parallel example, like when a case is filed against an officer who is holding a post, then prosecution has to be sanctioned by the government. So unless the sanction is given, that he or she cannot be prosecuted. Something of that sort, if we have an advisory board where a matter should not be allowed to be, or FIR should not be allowed to be registered unless there are prima facie material in the opinion of an objective view which is not represented not merely by the police but by an objective agency comprising of sitting judges of the High Court or some these are I'm not saying that these will just akin to what is there already tested under the National Security Act. If you have a material and it is approved, only then you can keep the person behind the bars. So also in a case of sedition, it should not be registered, in my view. It should not be allowed to be registered unless there is some objective agency which can see whether a prima facie case is made out against the person or not. And it is something, when and it is not something extraordinary that I'm suggesting, because even under the CRPC, when a case under the IPC is booked, then the matter goes before the magistrate to examine whether a prima facie case, whether the ingredients of the offence is made out not. It will go for sedition also, but by that time much water has flown. So at the time of registration, before the registration, if we can have some checks and balances, and suggestions may come from the members of the bar and the enlightened members, representative of the public. It requires collective thinking, because when a law is made or an amendment is introduced, whole lot of debate is there. So I would not really be saying that I'm only saying that it should be explored. What are the ways and means to check it? Right. And it can also be explored in course of the arguments, that whether it needs to be freezed and it should be done away with that. Also, that aspect also, and I'm quite sure all these aspects will be gone into, and that's why I said I welcome the move of the Honorable Chief Justice, where he has taken the initiative, where all dimensions of the repercussions and the impact of this law will get a relook, and something very useful would come out of it, which will be beneficial in the interest of the freedom of speech and expression in all its, visual, spoken, and whatever.
Okay. All right.
In every way, it can be looked into.
Okay. Interesting that you say, so maybe set up a independent panel or identify the authority that would fairly take a view on whether this section does apply, should apply or not, and then allow the investigating agency to proceed with it. Vivek Reddy, good evening to you. You're not just a BJP spokesperson, you're also an advocate yourself and you understand law. When the Chief Justice of India says, I don't know why this law is still there, does it need to be there 75 years after independence? And then when the government is bringing in so many laws, why can't you do away with this? Would you agree that perhaps it is time to do that?
Well, I think there is a distinction between abrogating or removing the law and keeping in checks and balances to ensure that the criminal law is properly put into motion. I think that's where the sort of confusion is. If you look at, if you ask me, well, my personal opinion is that this nation still requires a law on sedition. Definitely it requires. Why? Well, the straight answer is there were incitements made that a part of the country should be removed, that Assam should be removed from India. These were the sorts of incitement that clearly amounts to sedition. Well, so long as there is a potential to open up these issues, to bring up these issues, to create that sedition, to create that incitement, I think a law is necessary to check it. Every country needs a law. I agree with Mr. Vikram Singh, Dr. Vikram Singh, that the answer to the law, which is perhaps some people accuse that it was being wrongly used. The answer to the law is not to throw away the law. The answer is not to throw away the law. The answer is probably, could you bring in more checks and balances, as the learned justice, former justice of the Supreme Court suggested. If you could bring in those checks and balances, well, the law is properly put into motion and brought into execution. The question here is, Tanvi, today, as Dr. Vikram Singh put it, today, what is the threat perception in India? The threat perception of internal disturbance. This is the question where sedition lies. And we find that internal disturbance there is quite a serious threat, and the potential is increasing day by day due to terrorist activities. So how do you check it? Can any person say
But I
anything
thought
against the
terror
nation
activities
to
have
dislodge the
come
peace and
down
security of the people?
significantly
Can anybody
during
say
your
it's
government's
that way?
tenure. Vivek Reddy, but I thought you've gotten a great handle in dismantling those setups, and the terror activities and even the conspiracies themselves have significantly dropped
So long
under
as
the current
potential
government.
lurks. You're right. So long as the potential lurks, and the magnitude of that potential is ever
So
increasing.
is the UAPA law not enough for that?
Well, how does UAPA law address?
It's an anti-terror law.
Correct. That is against terrorism. What about incitement to terrorism?
What
What
is
about
incitement?
incitement to dislodge the sovereignty and the peace of this country? What about incitement to dislodge the government of this country? Elected government of this country? What about incitement to break this country? What answer do we have? Where are the laws for this?
Okay.
If a person makes a statement, can you say he's a terrorist? There is a dividing line between terrorism, between sedition, making oppressive statements against the nation to dislodge the nation. And there is a dividing line between inciting people to go and dislodge the nation, to go and dislodge
I
the
don't know of any
elected
attempt that
government.
has been made, at least in the last several decades, where anybody has undemocratically tried to dislodge a government in our country with
What about,
military means or whatever. I think not in our country. It happens in Pakistan maybe all the time, but not in our country. But Mr. Kailash Vasudev, okay, let me take this point across.
You cannot make sweeping statements like that.
It is quite possible you would want laws for that. Okay, I take the point. It is quite possible. You may need laws for that any which ways.
What
Yeah.
is it?
But
What is it? We need
there
an
is a
answer.
difference.
There should be a criminal law to rein in such people.
Which
who say
people?
India should be broken.
Which people
There should
today
be a
in
law
this country are trying to break this
Don't you
country?
agree that there should be-
Which people
there
are
should be
trying to
some
break
sense
this
of
country, Mr.
sanctity
Vivek Reddy?
For the independence,
21-year-old
integrity,
environmentalists.
sovereignty of this nation.
21-year-old
Don't you think there should be
environmentalists
some
are a threat to the
sanctity
sovereignty of your country.
Don't
Please,
you think that India
please,
must have
spare
some
me this
sanctity?
lecture, and I don't want to go down this.
not a
These
lecture.
rhetorics are meant for
If
any
you
other
feel for
channel.
India,
They are not
if
meant
you
for
feel
this
for India,
channel. I'm going to go
you
across to
call this a
Kailash
lecture.
Vasudev. Mr. Vivek
will
Reddy,
call
there
this
is no
a
point in
something that
talking
is
over
essential
me.
for the nation.
I have heard you out. Allow me to go to the other panelists now. Mr. Kailash Vasudev, then the debate comes to the point, what law will you have for people who indulge in commentary via their words or actions, oral or written, to incite people to wage a war against this country? You need to have a legal setup for that.
Waging war against the country is a totally different situation from sedition. Sedition means when you're going to do something with a different intent. Waging war is a different situation. The definition of sedition is very specific in this. Now you are speaking about the use of the term sedition and the offenses under it. The recent cases, all the people who have been arrested, or most of the people who have been arrested or charged for sedition, are citizens of this country. They might have taken a view which is contrary to government. They're not wanting to overthrow the government. They're trying to say, look, what is happening is wrong. People who have been charged for sedition are not granted bail. They die in custody. Then, when the cases are quashed by the courts, there is no action taken against those who have initiated the proceedings. Dr. Singh mentioned there's a standard operating procedure. I would like to know from him, in the standard operating procedure, which the police use within themselves for internal verifications, do they take action against those people where cases lead to an acquittal on these kind of charges? When the courts hold, these are all trumped up. Please understand, you are dealing with a democratic India. You're not dealing with a colonial India. It is not a colony to any individual party or a person. During the colonial Raj, even in those days, the courts came to the rescue of people like Bal Gangadhar Tilak and God knows whom you had. Today, we are trying to do the same thing, telling them, don't do this, this is wrong. Whether it is the High Court in Madras,
Mr. Kailash
whether
Vasudev,
it is the High Court.
the difference is that in colonial Raj, we said India should be independent. We wanted a free India. But now the difference is, in cases where sedition is charged, the difference is they're not saying we want a free and independent India, a strong India. They're saying we want a Tukde India. What do you say for that? There should be no sedition for that.
My
There should be
answer is,
government.
we have a free and independent India with a right under the Constitution.
So then,
What is
then
happening
you can
today is
freely and
constitutional rights
independently
to
say.
be abused.
Vivek Reddy, allow him to finish, please. You've asked a counter question. Allow him to at least finish.
Yes.
You have a constitution which you did not have before 1950. You had no rights before 1950. The Constituent Assembly recognized this
No,
position.
what do you say about this? To
Mr.
cut
Reddy,
off
can you
Assam.
argue? I'll keep quiet.
Isn't it waging war against the
You are
nation?
to-
Inciting people to cut off Assam.
This is-
Isn't that waging war against the nation or not, Mr. Kailash Vastev? You
They
are
are
a senior
raising
advocate of the Supreme
they're
Court.
raising
I'm a
voices
senior
in-
advocate of the High Court of Karnataka. Please tell me, isn't that sedition, inciting people to cut off Assam from India? Isn't that sedition or not? Please, I want an answer.
If it is
I really
sedition,
want to know your definition of
If
sedition.
it is sedition- No, no,
Is
no.
it democracy to say?
Vivek Reddy,
this
can
is
you
not
please
wrong?
allow him to answer before I have to interrupt every time and monitor you like a school principal here?
No, that is what you're not doing. You should have done that.
When you
You should have asked
finish
these
the
questions,
answer.
basic questions.
When
You
you finish
don't
the
need to
answer.
teach me my job. Can I just hear Kailash Vastev, please?
You see, it is a situation where in independent India, we are using this particular provision for all sorts of purposes where anyone speaks against the government. It has happened right from 1950 onwards. You speak against the government, you are charged for sedition. The charges are eventually not proved. Today, we are doing the same thing. From your statistics speak for themselves. Just read out the provision of sedition. I've kept it right here.
Between
Sedition.
2016 and 2019, the
Correct.
number of cases under Section 124 went up by 160%, while the rate of conviction dropped to 3.3% in 2019 from 33% in 2016. Mr. Vastev.
And what does this act say? Please see what 124A says. Whoever by words, either spoken or written, or by signs of a visible representation or otherwise, brings or attempts to bring into hatred or contempt, or excites or attempts to excite disaffection amongst the people. The government established by law shall be punished with imprisonment to life. Now, what does it mean? I make a statement today. Disaffection is what? I'm expressing my different view as against affection for the government. Now you're using that as a weapon for the purposes to suppress rights. Where does it say that there is waging war against the country? It is just disaffection against the people. Includes disloyalty. So therefore, we have to draw a distinction between what is waging war against the country, initiating actions to remove a government by violence. Satyagraha, non-violence, was disaffection. It was not sedition. We have lived on the principles of non-violence in this country. We have developed non-violence as a system to tell the world we can do and get independence without taking recourse to violence. That is the foundations of our systems. Today, what we are doing is we are making everything violent for the purpose of staying in governance. Karnataka court, all proceedings, yes. Please tell me these actions against very many people who are standing up for their rights, is that an action against the nation?
Journalists who cover stories, who report on stories which don't go down well with specific institutions or specific governments and authorities. Activists who stand up for what they believe in, specific policies of the government, be it at the state or the center. Farmers who are protesting for what they believe are essentially policies that will be detrimental to their livelihood. These are some of the biggest categories that are currently being booked frequently under sedition. The debate is open whether the sedition law itself should totally go away, or as you heard from our experts here, it needs to be made more specific. It needs to be redefined. It needs to be very clear on when and how it has to be used, and you bring in some checks and balances. That's where the debate lies. But every single legal expert and every single person who is a believer of free speech and an individual's right to dissent will tell you that this is a dangerous law that is more often misused than used for the right intended purposes, whatever they may be. Completely out of time. So I'm going to thank all four panelists for joining us on this conversation.